All right, the next case to come before the court is State versus McCall.
Me again, sir.
You're arguing again? All right, well, you know the rules, 15 minutes each and up to 5 minutes for rebuttal. You may proceed.
May it please the court, my name is Michael Stepanek, I represent defendant Arthur McCall. Mr. McCall is before this court for the second time on the same exact case. He had a motion to suppress a blood test 2 years ago now. The trial court granted it. This court affirmed it in its entirety. The reason that the state was able to take that appeal prior to final disposition of the case, they filed a 12K appeal. 12K appeal said that their ability to prosecute Mr. McCall has been destroyed, so they need to file an appeal now so that they can continue to prosecute him. They filed the appeal. This court said what the trial court did was fine. The state went back to the trial court and said, we can still prosecute him. Now, the state takes issue with the fact that, well, their certification, their 12K certification, only dealt with the pending charge, only dealt with one charge. It doesn't say that anywhere. The only thing that I see is that the state copy and pasted the exact language that 12K says, which is the ruling on the trial court's exclusion of evidence has rendered the state's proof with respect to the pending charge so weak in its entirety that any reasonable possibility of effective prosecution has been destroyed. So why does 12K only mention charge and not charge or charges? I don't know. It's just what it is. When it comes back, it says, if later in 12K, if an appeal from an order suppressing or excluding evidence pursuant to this division results in an affirmance of the trial court, the state shall be barred from prosecuting the defendant for the same offense or offenses. Why they have singular in one and they give you the option of plural in the second, I don't know. I didn't draft it, but I think that if they lose the appeal, they lose their case. I think it's very interesting in this particular case because the evidence that was excluded can be used for both an A1A violation, which is what they wanted to prosecute him for on remand, and the per se violation, which they didn't pursue after remand. So, 451119 says, look, you can use a blood test, which is the excluded evidence here, to prosecute for both offenses. So why did the state certify after that blood test evidence was gone, they couldn't prosecute him anymore? I don't know. But I don't think that they are able to continue to prosecute him. And I think that a lot of the question is whether the 12K certification creates a final order. There's a case from the Ohio Supreme Court, State versus Malinowski, and that basically, it was 12J at the time. It's now 12K. The evidence is, or I'm sorry, the language is the same. And it says, look, you've got concerns that you're going to have multiple litigation. The only way really that the state is allowed to do this is if they're certifying that it destroys their case. It says Criminal Rule 12J, it's 12K now, does not provide the state with an unfettered right of appeal, provides the defendant with protection from prosecutorial abuse, and harmonizes the appeal with the final order requirement of the Ohio Constitution. Under 12J, the state must certify the appeal is not taken for purpose of delay, and the complaint of ruling destroys the state's case because the state certifies the ruling destroys its case. The ruling is a final order. So I think that, at least according to the Ohio Supreme Court, the state would have to certify their case is destroyed. At least that's the language that Malinowski, which the Ohio Supreme Court uses, based on the same language in 12J as now 12K. And now the state is saying, well, yeah, we said that our case was destroyed. It's really not. It's just a little more difficult. And now Mr. McCall is going to have to, do further appeals. And I think that Malinowski says, look, this 12K, this is a protection for you guys because of the state's certification. The state had cited some cases saying that, well, you can go back and still continue prosecution, but I don't think any of those cases really say what the state thinks it says. There's a case, State versus Leckie, and actually there was no certification, there was no 12K certification that actually went forward with an appeal on that case. So what happened was there was a search of a house, and then a search of a car, the 12K certification, the First District Court of Appeals gave what I think is an advisory opinion, said that, well, this evidence that was found in the house that was suppressed had absolutely nothing to do with the car, so we'll just assume that they can still prosecute. There was no question or no issue at the Court of Appeals as to whether a final order was created, so that was very different than the instant case. There was never in that case even a 12K appeal that was perfected. I think that was an advisory opinion. I don't even think this should really count. And further, the Court of Appeals in that case said there's no question that the suppression order was limited to the search of the home. In this case, we've got one piece of evidence which the statute says can be used and should be used to prosecute both offenses. So I think that's very, very different. I just remembered I didn't reserve any rebuttal time, so I'd like to reserve the remainder.
Thank you. You may proceed.
May it please the court, Elizabeth Lindberg on behalf of Appellee of the State of Ohio. Arthur McCall was charged in this case with OVI and F3 in violation of 4511.19A1A with a specification. Second count being OVI in violation of 4511.19A1F, the per se violation with a specification, as well as driving under suspension in violation of 4510.11A. And the first assignment of error and both assignments of error are intertwined in lots of ways. But in the first assignment of error, Mr. McCall argues that in not dismissing the companion OVI charge, the trial court erred after this court affirmed the suppression order and therefore permitted an appeal without a final appealable order. In this case, according to RC 2945.67 and Criminal Rule 12K, they both establish the state's right to appeal the granting of a motion to suppress. This court held as much in State v. Dalchuk, 2003, Ohio 4152. A motion to suppress, as well as any motion which restricts the state in the presentation of certain evidence and renders the state's proof with respect to the pending charge so weak in its entirety that any reasonable possibility of effective prosecution has been destroyed, is a final order that the state may appeal. That's State v. Noble, also from this district, 2007, Ohio 7051. Therefore, as the trial court's suppression decision in Mr. McCall's case, not the certification of a 12K appeal by the state, is the final appealable order, this assignment of error is without merit. Notably, as stated in State v. Davidson from the Ohio Supreme Court, a final order must determine the action in the trial court. In McCall's case, in contravention of his argument that the entirety of the case must be dismissed, the trial court's final order only determined the action as to count 2 of the indictment, the per se OVI charge. That intertwines itself with Mr. McCall's second assignment of error. He argues that the trial court erred in permitting the state to continue to prosecute the case after certifying that any reasonable possibility of effective prosecution had been destroyed. This court will review that under a de novo standard of review. Importantly, pursuant to Criminal Rule 12K, the state filed a timely notice of appeal on May 6, 2014, certifying that 1, the appeal is not taken for the purpose of delay, and 2, the ruling on the trial court's exclusion of evidence in response to a motion to suppress has rendered the state's proof with respect to the pending charge so weak in its entirety that any reasonable possibility of effective prosecution has been destroyed. Importantly, the word charge is singular in the state's notice of appeal. It is limited to the per se OVI charge. Importantly, as Mr. McCall has argued, the blood draw was suppressed both by the trial court and by this court, and the blood draw exclusion, however, does not preclude continued prosecution on 4511.19A1A, nor the driving under suspension charge of 4510.11A. Ohio case law demonstrates that when an appellate court affirms a suppression order, Criminal Rule 12K only bars the state from prosecuting the same offense that relied upon the suppressed evidence, leaving the state free to prosecute the remaining offenses. In this case, only the per se OVI offense, 4511.19A1F, relied upon the suppressed blood draw evidence. Therefore, Criminal Rule 12K allowed the state to prosecute the defendant on the remaining 2 charges. The Ohio Supreme Court in Malinowski, as Mr. McCall argued, explained the purpose of a 12K appeal, in that Criminal Rule 12K gives the state an appellate remedy for a ruling, such as a suppression order that would adversely affect a pending charge. After certifying that as the state did above with the 2 outline requirements, if the appellate court affirmed the suppression order, which they did in this case, then the state is barred from prosecuting the defendant for the same offense or offenses, unless the state presents newly discovered evidence that it could not, with reasonable diligence, have discovered before the appeal. Mr. McCall asked this court to interpret Criminal Rule 12K so expansively that the affirmation of a suppression order based on a single piece of evidence would bar the state from prosecuting all charges against Mr. McCall, whether the suppressed evidence related to them or not. Notably, with the driving under suspension charge, the blood draw exclusion would have no relevance whatsoever to that charge, and therefore it would not make logical sense for that charge for the state to then be barred from continuing to prosecute on that charge. This interpretation defies 9th District and Ohio precedent. Ohio courts hold where a defendant is indicted for different offenses based on different evidence, the affirmation of the suppression of evidence related to one charge does not bar the prosecution of all charges under Criminal Rule 12K. In State v. Noble, this court, as cited previously, there was a motion in limine that the state could not use his previous OVI convictions to enhance his current charge, and for refusing to submit to a test by an officer because the prior convictions were constitutionally infirm. The trial court granted the motion, the state appealed under 12K, and this court affirmed the suppression, but noted that it pertained only to the specification, stating, the trial court's ruling deprived the state of its ability to effectively prosecute Noble on the specification of having previously committed 5 or more DUI offenses. Importantly, the court left the remaining charges untouched. In State v. Leckie, which Mr. McCall just spoke of, 1st District, 2014, Ohio 1527. The police searched the defendant's automobile and home, and as a result, the defendant was charged with counts based upon evidence from both the car, 2 counts from the car and 3 counts from the home. The trial court granted the defendant's motion to suppress evidence found in his home. In denying the dismissal of counts arising from the automobile, the 1st District Court wrote, in this case, the state made no attempt to appeal anything except the suppression order relating to the search of the house. The notice of appeal, not the Criminal Rule 12K certification, delineates the matter appealed from. The suppression order, which was identified as the subject of the appeal in the state's notice, dealt only with the search of the home. The search of the home inarguably related only to counts 3, 4, and 5 of the indictment. Thus, the only counts of the indictment implicated by the attempted appeal to this court were counts 3, 4, and 5. Accordingly, Criminal Rule 12K could not bar prosecution from counts 1 and 2 because they were not the same offenses at issue in the state's dismissed appeal. Therefore, ultimately, the 1st District held the same offense or offenses refers only to the offenses that rely upon the suppressed evidence. The remaining offenses may be prosecuted. In State v. Finney, a 6th District case, 2008 Ohio 5795, the defendant was indicted on 4 felony OVI violations, with counts 1 and 2 in violation of A1A and counts 3 and 4 in violation of A2. The trial court granted the defendant's motion to dismiss counts 2 and 4 based on improperly journalized judgment entries of past OVI convictions. The state appealed pursuant to 12K. The appellate court affirmed the order. Subsequently, the defendant moved to dismiss the remaining counts, arguing, like McCall presently, that the state's appeal barred the prosecution of all charges. However, the 6th District held that the state's appeal was limited to the offenses related to the suppressed evidence. The 11th District in State v. Canino, 2013 Ohio 551, the trial court granted the defendant's motion to suppress breathalyzer evidence. The state appealed pursuant to 12K. Despite reversing the suppression order, the 11th Circuit noted the limited nature of the state's appeal, stating a pretrial challenge to a breathalyzer test, if granted, destroys the case under former RC 4511-19A3, and the state is permitted to appeal pursuant to 294567 and Criminal Rule 12K. Notably, the Canino court emphasized that the suppression of a breathalyzer test would only affect the state's ability to prosecute A1D, leaving the remaining charges unaffected. Here, the defendant's motion to suppress was granted only for the evidence of the blood draw and its results. The suppressed blood evidence related inextricably only to the per se OVI charge, count 2, in violation of 4511.19A1F, which requires that the person has a concentration of 0.17% or more by weight per unit volume of alcohol in the person's whole blood. The remaining charges in McCall's case, however, do not rely solely on the suppressed blood evidence. Some of those facts that were elicited were that on February 23rd, Elyria police officers, 2013, Elyria police officers responded to numerous complaints that a car was sitting in the northbound lanes of Lorain Boulevard at Foster Avenue and was not moving. The car was stopped on the roadway and the traffic light was green. The brake lights were on. The driver was passed out or sleeping and unresponsive. Officers tried knocking on the windows and yelling, but the driver would not wake up. Another officer could smell alcohol coming from the car. They identified the driver as Arthur McCall, and the officers noticed that there was an odor of alcohol coming from McCall's person. McCall's balance and coordination were off, and he was resisting, so the officers placed him in handcuffs. One of the officers also noticed that McCall's eyes were glossy and red. All of that information would be sufficient to use for purposes of count 1, the count 1 OVI charge that was not the per se charge requiring a level of alcohol in the blood, and would be pertinent to use for purposes of prosecuting Mr. McCall on that first count. It would not, again, logically follow that because the blood test was suppressed, that then the state could not continue to prosecute for the first charge of OVI, where a blood test is not required under the statute at that section. Also, finally, Mr. McCall ended up pleading no contest to counts 1 and 3 of the indictment, and it has now come to this point where we're in an appeal. But in Ohio, a plea of no contest is an admission of the truth of the facts alleged in the indictment. Therefore, since only the blood draw evidence was suppressed and the state's appeal of the pending charge was limited to count 2, the per se OVI offense, the no contest plea and underlying facts are sufficient to uphold the conviction and sentence in this case. For the foregoing reasons, the state asks this court to affirm the decision of the trial court and uphold Mr. McCall's conviction and sentence.
Thank you.
Thank you.
The state just advised this court of how they still had a really, really good case against Mr. McCall, notwithstanding the blood test evidence, but said that they still stand by their original certification that their case was destroyed. Their certification to this court was not in any way limited to the per se charge. Their notice of appeal does not say that they are only filing an appeal as to the per se charge. If it did, I wouldn't be here. It's just not true. What the state just advised this court, that it was limited to the per se charge. This is a final order, according to Malinowski, not because it limits the state in its ability to present evidence, but because of the certification saying that our case is destroyed. The Noble case that the state cited, that discussed the difference between a motion to eliminate and a motion to suppress, and this court said, look, when it comes to a 12K appeal, if it's jamming up your case, you can't convict the guy. That's what we're looking for a 12K appeal. This court then permitted the state to do a 12K appeal. There was nothing about what happened on this case to remand. There was zero instruction to the trial court, leave all the other charges intact. So I think, yeah, there are a lot of these 12K cases where there is no direction to the trial court what is going to happen afterwards, and because there's no direction, because there's no language dismissing the remainder of the charges, the state thinks that those cases stand for the proposition that continued prosecution is okay. That's not the holding, that's not even suggested in any of the cases that the state has cited. Some fella gets indicted for trafficking in heroin and trafficking in cocaine. I'm talking about cocaine this morning. And there's a search warrant executed at his residence. This trial court then suppresses the evidence that's found in the house. The state says, our proof with respect to the pending charge is rendered so weak, etc. Case goes up to the Court of Appeals, gets affirmed. The state says, wait a second, we were only talking about the cocaine, we weren't talking about the heroin. Where are you guys getting this? We just said charge, singular. That's the language from 12K. Why the legislature only put it there, I don't know. But if the state copies and pastes, they're left with the one charge. This permits them to do exactly what Malinowski said they shouldn't be able to do, was just have an unfettered right to appeal. The state's telling you, we had a great case against Mr. McCall. We didn't need this evidence. The statute says we can even use this evidence. They didn't like the fact that the trial court suppressed the evidence. I get it, I wouldn't be happy either. Then just prosecute him for the other felony OVI. The fact that it has nothing to do with the driving under suspension, it's your choice to appeal it. You don't have to appeal it. You only appeal it if it's going to say that, you guys have no case. The prosecutor just told you, we had a great case. We had a great case. Did it destroy their case? No. That's why Malinowski said, there are ethical concerns. This is something that's to protect the defendant. And the story that I put in my brief was absolutely true. Absolutely true. I was in a murder case, and anecdotally even, isn't anything to be cited. Prosecutor says, hey, the trial court grants this motion to eliminate, and I don't like it, I'm just going to tell the Court of Appeals that I'm taking the 12K appeal on a misdemeanor charge.
You know we can't consider that.
No, but it's an example, it's what is going to happen.
So we need to just, you can speak hypothetically.
Then hypothetically, that's...
You can speak hypothetically what a prosecutor could
Sure.
do, but you can't say a prosecutor told me this.
I get it. Hypothetically, a prosecutor could say that, just like the cocaine and heroin example I just gave you. The state now, if this court upholds what they did in this case, has a way to appeal as many times as they want, as long as there's more than one charge in the indictment. And I don't think that's right. I don't think Malinowski, the House Supreme Court, thinks it's right, and I hope you don't either. Thank you.
Thank you. Thank you. Thank you both for your presentations to the court. The court will take the matter under advisement and issue a written opinion, which will be sent to both sides, as well as we will release it on the website.